First item on the agenda, Chair Becker Finn, would you like to move to recommend that House File 3872 be placed on the general register?
Yes, Mr. Chair, that is my motion, and then I would also move the DE3 amendment before us.
Thank you, Madam Chair. Please go ahead and speak to the DE3 amendment.
Yeah, so there's a couple things we're adding. So I will then move the A3 amendment to the DE3. The A3 contains two sections from House File 3506, which was the Representative Stevenson collateral source bill. So not adding the entirety of that bill, but just a couple sections from it. So that would be the A3 to the DE3.
Madam Chair has moved the A3 amendment. The A3 amendment is before us. Members, any discussion to the A3 amendment? Representative Niska.
Thank you, Mr. Chair and Representative Becker Finn. I just was hoping you could explain what is the legal effect. I guess we have two sections now that we've taken from that bill that we previously heard, and I was just hoping you could explain what. I guess I'm mostly interested in Section 2 now, which I think was Section 4 from before, the reallocation piece, changing the word a from any, or a to any. What change is that going to have practically in collection of a judgment?
Chair Becker Finn.
Thank you, Mr. Chair. Well, as you noted, we're changing the word a to removing a and adding any. So instead of just one person, it would apply to any party.
Representative Niska.
Thank you, Mr. Chair. And Representative Becker Finn, that seems fairly minor to me. What is the problem that's created by having the word a there instead of any?
Chair Becker Finn.
Thank you, Mr. Chair. I don't know that I'd say it's a problem. It's just this was what Representative Stevenson had been working with the parties to try to find the things that were least objectionable to folks, and this was a change that folks were willing to agree on.
Representative Niska.
That's all I have. Thanks.
Seeing no further discussion to the A3 amendment, Chair Becker Finn renews her motion to adopt the A3 amendment to the DE3 amendment. All those in favor say aye.
Aye.
Any opposed? Motion prevails. Representative Feist, would you like to move the A2 amendment to the DE3?
Yes, so moved.
We have the the A2 amendment to the D3 amendment in front of us. Representative Feist, would you like to speak to the amendment?
Yes, thank you. So this is the guardianship immunity language that we heard before this committee, addressing a 2022 Court of Appeals case that surprised everyone in saying that guardians have absolutely no civil liability whatsoever, no matter how egregious their behavior. So this reflects some amendments to the language based on conversations with stakeholders, as well as some language to permit guardians to resign if there is no successor guardian in limited circumstances, also based on conversations with stakeholders.
Any further discussion? Representative Niska.
Thank you, Mr. Chair, and Representative Feist. Thank you for the work that you did with stakeholders on this. I think this does get a lot more towards a sort of narrow fix of that particular problem raised there without potentially creating other damage other places. So I do really appreciate that. I did want to just note that this issue and the way that this bill came up before us, I think is a really, really important reminder to us about how difficult our process can be for other people out in the world who maybe are very, trained and focused on and interested in a particular issue, but they might not even really fully understand the changes that we're making. It was eye-opening to me that there were so many people who were interested and had a strong view about what we were doing, who I hadn't heard of before they, happened to come to the hearing and try to speak up. And so it's good that they were able to catch it, at least at that point. But I think we should be a little humble, we should be pretty humble in this process about there are lots of people out there in the state of Minnesota who might know things about a particular area that we're working in and might not even know that they should be coming to us to share their perspectives. So, but I really do appreciate, Representative Feist, the work that you've done on this to really, focus in on what I think we all agree is a problem that should be corrected. So thank you.
Chair Becker Finn.
Yeah, thank you, Mr. Chair, and just wanted to comment, I teach legislative process, and part of that is sort of making sure that folks who are not paid lobbyists understand how this place works. So I appreciate the comment and would encourage others to give weight to the general public just as much as folks listen to the folks who are paid to be here. So totally agree with you that we could all do better on that.
Thank you, Chair.
And would support the A2 amendment.
Thank you, Chair Reckerfan. Thank you, Representative Niska. Yes, there are a lot of smart people out there in the public. They don't just reside here. Any further discussion to the A2 amendment? Seeing no further discussion to the A2 amendment, Representative Feist renews her motion to adopt the A2 amendment to the DE3 amendment. All those in favor say aye.
Aye.
Any opposed? The motion prevails. Madam Chair, now to the presentation of the DE3 as amended.
Yeah, thank you, Mr. Chair. So this is our policy omnibus bill for the year. So thank you for making all those motions, Mr. Vice Chair, getting in the bill the shape that we would like. I will just, I do want to thank staff. It's been, for folks who are not aware, one of our researchers is away on National Guard duty, and this last couple of weeks has been especially challenging for our staff being down on members. So I just want to give a shout out to all of you. And to that, one of our researchers is out sick today. So she was going to do the walkthrough, but I can handle it. But just wanted to note that because it has been especially difficult in the public safety judiciary space to be down, down a team member this year. So the DE3, I'll just go through real quick, and then I know there's a couple other amendments. So it contains House File 4326, which was the Representative Curran bill on judicial and court safety. It also has House File 3830, which was the Representative Holland's bill that we moved earlier this week, just clarifying the anti-nuptial agreements, changing the language to any two people instead of having the language gendered. 3872, the underlying bill, those provision, that was the judicial branch finance and policy bill. We took the policy provisions and they're still in this bill. There were a couple of sections, section 7 and 9 that we discussed relevant to service of OFPs, and those are actually being carried in the public safety omnibus bill. So didn't want folks to think we didn't think that was important. It's just public safety is carrying those provisions. Then, as we noted, we added some language from House File 3483, which was the Representative Feist bill on guardianship. Also includes the policy-only provisions from the Board of Public Defense bill, House File 3607, Representative Finke's bill, and Representative Curran's House File 4276, which was the language we passed earlier this week, changing the terms husband and wife just to spouse. And then finally, we added those couple of provisions from the Representative Stevenson a collateral source bill. So not the biggest policy omnibus, but important nonetheless, and happy to go to public testimony.
Thank you, Madam Chair. And I have Sarah Strong on the list. Please come on down. Please introduce yourself, share your pronouns if you like, and proceed.
Good morning, Mr. Chair, members. My name is Sarah Strong. I'm here on behalf of the Minnesota Newspaper Association, which represents 260 newspapers across the state, to express opposition to Sections 5 and 9 of Article 3. These sections would eliminate the longstanding requirement that important notifications issued by the judicial branch be published in newspapers. Instead, those notices would be posted on a judicial branch website. When M&A met with judicial representatives, they cited a few reasons for the proposal. First, that these notices should be available online, which they currently are. State law already requires that notices published in newspapers must also be posted on the newspaper's website, in front of any paywall, and on the statewide public notice website at no additional cost to the advertiser. Second, that these notices should be searchable, and they currently are. mnpublicnotice.com, the statewide public notice website, is searchable and contains all required public notices for the entire state. Third, that placing newspaper notices is an administrative burden. M&A assists other state agencies and public entities to place public notices efficiently and welcomes the opportunity to continue talking with the judicial branch about how they can assist them in making the publication process more efficient. When published in local newspapers and posted on their websites, those notices will be widely seen. 86% of Minnesota adults read their local print or digital newspapers each month. We are confident that public notices in newspapers and on their websites are more likely to be seen by the parties who are subjects of the notice or by others who know those parties than those posted only on the judicial branch website. Public notices placed in newspapers as a means of alternative service of process of legal documents has been validated by decades of experience and practice. Making this kind of dramatic change could raise questions about the legitimacy of service and invite due process challenges. The cost of publishing these notices has been reported to be roughly $240,000. Informing affected individuals and the public about important legal proceedings is an appropriate use of such a modest amount of the judicial branch's budget. The Newspaper Association respectfully requests the committee remove these sections. Thank you.
Thank you, Ms. Strong. Are there any members of the public who wish to testify on the DE3 as amended before we move to the other pre-filed amendments? Seeing no other members of the public, Representative Scott, would you like to move the A4 amendment to the DE3 amendment?
Vice Chair Fraser, yes, I would.
Representative Scott, go ahead and speak to the amendment.
This just narrows the protections for the judiciary branch and what their ask is in Article 1. I just feel it's so broad, and that other agencies, other units of government are going to come, and this is going to be precedent setting. They're going to come and they're going to want the same protections. And I think also from a practical standpoint, it's going to be really difficult for local units of government and other entities to keep up with who's an employee of the judiciary and who's not, and who's protected and who's not. And I just feel like that really, for transparency purposes and for practical purposes, I felt that that language was too broad, and so I would ask for your support on the A4. Thank you.
Chair Rebecca Finn.
Thank you, Vice Chair. So interestingly, the lead in the public safety had the opposite opinion of you. I believe lead Novotny said, "What makes you so special?" was the quote. So we actually think that keeping the language as it is actually the middle ground between your position and lead Novotny's position. Lead Novotny actually wanted to expand it to even more people. I wasn't so sure about that. And so keeping the language as it is actually the middle ground between the two arguments to just keep it to judicial folks. So would oppose the A4 amendment.
Thank you. Any further discussion, members? Representative Scott.
Thank you, Vice Chair Fraser. Well, that's the great thing about this place is even people within their own party can disagree on things, and I just would ask for member support. This is precedent setting. It's far too broad, and I would ask for member support. Thank you.
Seeing no further discussion, Representative Scott renews her motion to adopt the A4 amendment to the DE3 amendment. All those in favor say aye.
Aye.
All opposed?
No.
The motion does not prevail. The motion is not adopted. Member discussion on the DE3 as amended. Representative Carroll.
Thank you, Chair, and this is for the author. You and I have a common experience in Hennepin County Family Court. So, as you know, there's judges, there's there's referees, and then there's magistrates. So looking at personal information in Section 2 regarding the definition of judicial official, it seems that it covers, obviously, judges and then referees. But I was wondering about magistrates. As I recall in Hennepin, they're under contract, so they're not technically employees. They're probably 1099 folks. So do you intend to cover magistrates in this as well? And I'm looking at...
Representative Carroll, can you pull your mic a little closer?
Sure.
Thank you.
Looking at Section 2, regarding in line 2.2, employees of the judicial branch. Can you comment on that, please?
Chair Rebecca Finn.
Thank you, Vice Chair. The intention is to cover all judicial officials. If there are unique hiring practices in individual counties out of all 87 counties, I'm not really privy to that. If you would like to bring an amendment to make that more clear, you are more than welcome to do so.
Thank you. Thank you.
Are you done? Representative Carroll?
That's fine. Thank you.
All right. Any other member discussion? Johnson.
Vice Chair Howard, Chair Becker Finn, or Fraser, I'm sorry.
That's all right. It's early then.
It's way too early.
They look so similar.
Wish I had that hair.
I do have concerns about the public notice issue. Even in my area, 50 miles north here, we have areas that the only type of internet they have is dial-up. We don't have broadband. We don't have DSL. They have to call in on their phone, hook up their computer with dial-up. Now, these public notices in the papers are important because there's a lot of times it's the only way that these people are going to find out that information, what these public notices are. Is it down the road a possibility to change that? Yes, but we're not there yet. We have a lot of areas of the state that do not have access to the internet. We have a lot of kids yet that to do their homework, they have to go to the library. They have to go outside McDonald's to hook up to the internet to do their homework. So I think this is a little premature right now, and I think we need to really look at that and possibly fix that because it's right now, without that paper, it's the only way a lot of people are going to get these court notices and these court notifications.
Chair Rebecca Finn.
Thank you, Vice Chair. And I will note for the record, I know there are probably some members of the legislature who don't remember dial-up internet, but I did live in rural Minnesota when dial-up internet was a thing, so I'm well aware of the technology. I think we've had this conversation on and off throughout the years as technology has changed, and I think, we're just at the point where technology is at a point where it makes sense for us to make this change. I understand that there are some business interests and that it is challenging to own a newspaper publishing company in 2024, but I think that's just the nature of the change of technology. So I hear you. I also have students in my district who don't have internet at home, but as you noted, there's lots of public places where it is available.
Thank you. Any further discussion? Representative Johnson? All right. Seeing no further discussion, Chair Becker Finn renews her motion to adopt the DE3 amendment as amended. All those in favor say aye.
Aye.
Any opposed? The motion prevails. Now to House File 3872 as amended. Chair Becker Finn renews her motion to recommend that House File 3872 as amended be placed on the general register. All those in favor say aye.
Aye.
Any opposed?
No.
Motion prevails. On your way.